Hello, this is Anne Twomey from the University of Sydney. I'm going to take you through a discussion, well, really just me discussing, on government accountability and virtual parliaments during this age of pandemic. Now, the Commonwealth Parliament, as you know, has adjourned its sittings. It did so in March due to the COVID-19 pandemic, and it wasn't scheduled to resume again until August. We've recently found out, however, that it will sit on Wednesday, the 8th of April, to pass additional urgent legislation. The usual budget sittings of May and June, however, have been cancelled, and the budget won't be handed down until October. In the meantime, supply bills have been passed to ensure that ordinary government expenditure is funded until well after the budget is now due to be handed down. An important consequence of this is that there will be very little parliamentary scrutiny of the government for nearly 5 months, and this is during a critical period in which extreme powers will be exercised. How can we then ensure that government remains accountable while still being able to fulfil its functions and without putting the health of MPs and their staff at risk? Parliament has only been adjourned, not prorogued, like the recent controversy in the United Kingdom. Now, this means that Parliament's committees, of course, can still function. The Senate Standing Committee on the Scrutiny of Delegated Legislation can therefore play a very important role in checking and reporting on all regulations and other forms of delegated legislation made during this period, particularly in relation to giving effect to emergency measures. This committee announced on the 1st of April that it would continue to meet and report to the Senate regularly, and to apply its 12 technical scrutiny principles to Commonwealth delegated legislation. This includes whether the delegated legislation trespasses unduly on personal rights and liberties, and whether it contains matters more appropriate for parliamentary enactment. The committee said it would write to all ministers, setting out its expectations, including time limits to be placed on delegated legislation, and any concerns about delegated legislation trespassing on personal rights and liberties, or where it amends primary legislation, and about the need for explanatory statements which make clear the necessity for delegated legislation and the safeguards to protect personal rights and liberties. To aid transparency, the committee will also publish all COVID-19 related delegated legislation on its website, so that will be quite helpful as a way of finding together where they all are. During a human biosecurity emergency period, which was declared to exist by the Governor-General on the 18th of March, Sections 477 and 478 of the Biosecurity Act 2015 permit the Minister for Health to determine emergency requirements and make directions necessary to prevent or control the establishment or spread of the disease within Australia. These determinations and directions are not subject to disallowance. They also apply, quote, despite any provision of any other Australian law, unquote. So they're effectively a very large Henry VIII clause. Failure to comply with them also constitutes a criminal offence. Now, normally, non-disallowable instruments are outside the scope of the Senate committee's field of consideration. That's the Committee on the Scrutiny of Delegated Legislation. But in this case, the committee may consider instituting an own motion inquiry into these instruments if the Senate doesn't directly refer the matter to the committee in the limited time available when it next sits. Other parliamentary committees, such as those concerning legal affairs or the Public Accounts Committee, may also provide useful scrutiny of government action. The Auditor-General also may play a significant role in ensuring the efficiency and effectiveness of large government spending programs. New Zealand also has an Epidemic Response Select Committee comprised of members from all parties and chaired by the opposition leader. It has a majority of opposition members on it. It will meet on Tuesday, Wednesday and Thursday mornings, and its meetings will be streamed live to the public. The intention here is to boost public confidence by providing effective scrutiny of government measures. And making sure there was a non-government majority on the committee was quite important to achieve that. Now, there's lobbying in Australia for an equivalent committee, but there's also a good argument that existing committees, such as the Committee on the Scrutiny of Delegated Legislation and the like, should continue to exercise their own expertise in conducting scrutiny, rather than just having one committee doing an overall higher level type of scrutiny. It might be good to have an extra committee doing that, but I don't think we should take things away from the existing committee system where you've already got people with particular expertise in the areas that they would normally address. Now, it's important to understand that parliamentary committees can already operate using technology so that their committee members, staff and witnesses can remain physically isolated while communicating with each other. Such meetings are still regarded as parliamentary proceedings for the purposes of the application of parliamentary privilege. For example, Standing Order 235B of the House of Representatives provides a committee may conduct proceedings using audio-visual or audio links with members of the committee or witnesses not present in one place. If an audio-visual or audio link is used, committee members and witnesses must be able to speak to and hear each other at the same time, regardless of location. Senate Standing Order 30 also permits Senate committees to hold meetings by electronic communication without the members of the committee or witnesses being present in one place. Accordingly, there's no reason why parliamentary committees should stop performing their scrutiny functions while Parliament is not sitting. Indeed, there are very strong reasons why they should. In addition, the absence of parliamentary sittings would actually free up more time for this activity. If parliamentary committees can engage in parliamentary proceedings with members and witnesses participating by way of technology links, is it possible for Parliament to sit in the same manner, as a kind of virtual Parliament? It may prove necessary in the course of the next few months to enact urgent legislation so that some facility to assemble Parliament and to pass laws in this way would be a good safety net for the current circumstances. Now, it has been suggested that the Constitution forbids such action. To me, however, it's not abundantly clear that that is so. Certainly, the framers of the Constitution did not envisage Parliament sitting with members dispersed around the country communicating by way of technology. But they did recognise that communications technology was quickly changing in the 1890s and that those changes did need to be accommodated. It was for this reason that they gave the Commonwealth Parliament power to legislate with respect to postal, telegraphic, telephonic and other like services. The phrase other like services was intended to pick up then unknown but future developments in technology, such as broadcasting of radio, television and the internet. The Constitution is commonly interpreted by the Court in a manner that does accommodate changes in facts and technology. So the absence of such technology in the 1890s ought not be a barrier to interpretation of the Constitution in a way that accommodates it today. So what does the Constitution actually say about where Parliament must sit? Section 125 of the Constitution provides that the Parliament shall sit at Melbourne until it meet at the seat of government, which shall be in a territory located in New South Wales, not less than 100 miles from Sydney. Now, no one's been absolutely sure where the seat of government is. We know it's somewhere in the ACT and somewhere in Canberra, possibly the Parliamentary Triangle, possibly bigger than that, but certainly Parliament, where Parliament House is, would fall within the seat of government. So Parliament needs to sit there in the seat of government which is in the ACT. There therefore needs to be some kind of geographical location for its meeting. But that could be accommodated by having the minimum number of key personnel actually located in the parliamentary building, or at least close by. So you could have the relevant presiding officer, perhaps a minister, located in Parliament House, hosting the electronic meeting, with the rest of the members participating by logging in from elsewhere by some kind of electronic means. I think in those circumstances you could still say that Parliament was sitting and meeting in the seat of government. The Constitution also refers to the attendance of members. For example, Section 20 provides that a senator's office shall become vacant if he or she, without permission, fails to attend the Senate for 2 consecutive months of any session. Section 38 provides the same for members of the House. But there appears to be no reason why attendance may not, with the permission of the House, be by electronic means. Similarly, sections 44 to 46, about which members of Parliament might be quite sensitive at the moment, refer to members and senators sitting, but one could also still sit by participating in parliamentary proceedings by way of technology. Most importantly, sections 22 and 39 require, until Parliament otherwise provides, that the presence of at least 1/3 of senators or members to constitute a meeting of the Senate or the House of Representatives for the exercise of its powers. Now, these are the provisions that most people point to as an impediment to the existence of a virtual Parliament. But these provisions permit Parliament to otherwise provide, which indeed it actually has done in relation to the quorum, which has been reduced by legislation. So it's not clear why Parliament could not also provide so as to legislate about permitting that presence to be a virtual presence through participation by electronic means in circumstances such as those now prevailing. So how could you do all this? Well, there are basically 2 options. Section 50 of the Constitution allows the Houses to make rules and orders with respect to their business and proceedings, normally known as standing orders or sessional orders. Now, this is what was done when the Houses, through their standing orders, permitted members and senators to participate in parliamentary committees by electronic means. The standing orders of the Parliament could therefore be changed by a vote of an absolute majority of the House. The second option would be, and I think this is a safer option if one was being prudent, and that is to enact legislation to permit it. This would amount to Parliament otherwise deciding for the purposes of sections 22 and 39 of the Constitution. And it would also be wise to require in that legislation that the presiding officers be situated in Parliament House and host the meeting of Parliament from there, so that we could be sure that we're satisfying section 125 of the Constitution with reference to the meeting of Parliament within the seat of government. Now, a key consideration would be to ensure the identity of all the participants by making audio-visual technology preferable so that various participants could be seen and heard and known to be the people who are participating. Another requirement would be to ensure that all members in the virtual chamber could hear and communicate with each other. And this was the condition that we saw in the standing orders in relation to parliamentary committees. The best method would need to be ascertained for recording votes, along with ways of resolving any disputes about whether a vote was correctly recorded or not, or how to deal with unintended absences that result from failures in technology. So, for example, if a person tried to vote and the system crashed or their internet failed or whatever problems arose. Now, what preparations have actually been made to do this? Well, on the 23rd of March, which was the last sitting day, in the House of Representatives, the Attorney General, Christian Porter, moved 2 critical motions, and equivalent motions were also moved in the Senate. Now, the first motion changed the House of Representatives sessional orders so that it could meet in a manner and form not otherwise provided in the standing orders, with the agreement of the Leader of the House and the Manager of Opposition Business, with the manner in which members may be present, including, for the purposes of achieving a quorum, to be determined by the Speaker. Now, this note potentially permits MPs to participate in Parliament by electronic means if the major parties and the Speaker agree. An assurance was given at the time during the debate on this provision that this motion was being moved for the purpose of enhancing greater participation in parliamentary proceedings, including from the crossbench, rather than being a means of limiting it. The second motion was to amend the standing orders so that with the agreement of the two major parties, the standing orders can be amended without the need for an absolute majority of MPs. This means that there will not need to be an absolute majority of members available in Parliament in order to change the order of business, so that when Parliament resumes, like it will on Wednesday, for a short sitting to pass urgent business, it can be done with simply a quorum available rather than requiring an absolute majority as occurred last time on the 23rd of March. Both these measures, I think, were wise precautions and both of them were passed. Now, what about the states? Could they hold virtual parliaments? In New South Wales, we've seen an op-ed in the newspaper by the Speaker of the Legislative Assembly suggesting that this would be a good idea. Now, in relation to each state, one would have to consider the constitutional provisions in the state constitution and whether or not those provisions are entrenched and how they can be changed if necessary. So the only example I'm going to give here is New South Wales, but you can of course go and have a look at your own jurisdiction. So in New South Wales, the key provisions are sections 22H, 22I and 32. They provide that the presence of at least 8 members of the Legislative Council and 20 members of the Legislative Assembly, in both cases excluding whoever the member is presiding, are required to constitute a meeting of the House for the dispatch of business. So if you don't have that quorum present, then you cannot proceed to do any business. Equally important are the provisions that say all questions arising in the Houses shall be decided by a majority of votes of the members present. Now, fortunately, none of these provisions actually is entrenched in the New South Wales Constitution, so they can be amended by ordinary legislation. There is no need to hold a referendum. Alternatively, changes could also be made by standing orders to permit presence by means of electronic participation. In addition, after Parliament has been prorogued in New South Wales, the Governor may fix the time and place for the holding of the session of Parliament. So unlike at the Commonwealth level, at the state level in New South Wales, there is of course no requirement to sit in the seat of government. State Parliament doesn't have to sit in Parliament House, it can sit elsewhere. So conceivably the Governor could nominate the place of sitting as being a virtual location. Now, is anyone else actually doing this? Well, there's been quite a deal of thought about this in the current circumstances in a number of jurisdictions, but of course it is quite difficult to make these kinds of changes quickly and to make sure that the technology is up to scratch in doing it. But there are some examples of what other parliaments have done. So the EU Parliament is sitting remotely at the moment and it's voting, but in a rather clunky way. It's doing it by email. Apparently they send out the email with the voting forms. The member then votes, signs it, then scans it and then sends it back. Probably not the most efficient way of doing it, but maybe more secure. New Zealand, as noted before, is using a parliamentary committee to provide oversights, and it's meeting online, so it's doing it remotely and then broadcasting it over the internet for anybody who wants to watch. So there's greater public scrutiny by doing that. In the United Kingdom yesterday, there was an editorial in the Times of London calling for this virtual sitting of Parliament. So there's certainly discussion about it there in the UK. In that article, it also said that the Swedish Parliament had been meeting with a much smaller number of MPs, 55 out of 349 MPs being present. And it also said that the Welsh Assembly had appointed an emergency synod with a small number of MPs in order to be able to hold the government to account. So different places are thinking about different ways of doing this, but it's the sort of thing where actually Australia could be in the forefront if we chose to move in this direction for these emergency times. The final point I want to make is about the importance of maintaining public confidence. In an emergency, maintaining public confidence in the government is essential, especially when you're asking very hard things of the people, especially when you're restricting their civil liberties, their ordinary day-to-day freedoms, and taking decisions that affect them economically as well. In order to maintain that level of public trust is terribly important, and to do that, you need some kind of level of parliamentary scrutiny, I think. Parliamentary committees, as I said at the beginning, are a good way of doing that. So we've seen, as I said, the Parliamentary Committee dealing with the scrutiny of delegated legislation, announcing that it's going to be active in this area, and we've also seen lobbying to try and get dedicated kinds of parliamentary committees to do that. In New South Wales, there is a special committee that's been established to monitor how the government is acting in relation to the COVID-19 pandemic. So specialised committees, as well as the actions of the general committees, are good ways of dealing with this. An additional way, however, of maintaining public confidence in the government is to ensure that Parliament can continue to sit, to be able to scrutinise government action and to represent the wishes of the people, as well as pass any necessary legislation. Much better to be passing these types of emergency rules by way of legislation than by using regulations with Henry VIII clauses when they're non-disallowable. From a democratic point of view, legislation is always preferable. And finally, while ordinarily Parliament should sit by way of physical presence in the parliamentary chambers, there is good reason during a pandemic to ensure that such scrutiny and representation can occur by electronic means. And in my view, the Constitution does not impede that from happening.